That's a really good question as well. And most people sort of confuse the terms custody and placement, so I'd like to sort of distinguish them for you. Custody is decision making. It has nothing to do with where the children are going to live. And in Wisconsin, and it's been the law for a number of years, there's joint custody. And joint custody means that both parents have equal input and say-so over major decisions involving their children's upbringing. And those decision-making topics involve such things as religious decisions, schooling decisions, health decisions, when a child may be old enough to drive a car. Sort of day-to-day decisions each parent makes on their own when the children are with them, but major decisions, both parents have equal footing and need to discuss those issues. If a parent has sole custody, that means that that parent is allowed to make all major decisions involving the children without input, without equal say-so from the other parent. So that's custody. Placement has to do with where the children are going to live. I want to sort of give you a quick history lesson. In the past, a number of years ago, most courts, if custody and placement was contested, most courts usually placed children predominantly with one parent, and then the other parent would visit the children typically every other weekend and perhaps once or twice for dinner during the week. And more often than not, that perhaps was the mom, the wife. About 15 years ago, Wisconsin created a equal placement law in the state of Wisconsin. And that statute allows the court to set what's called significant and meaningful periods of placement with both parents when they get divorced. Again, sometimes we do see traditional placement arrangements in the state of Wisconsin, but more often than not, parents are sharing children. They do have equal placement. And parents can agree as to those things, and if they don't agree, then the court will decide the placement of the children. And there are a number of factors that would go into the judge deciding where the children are going to live. The wishes of the children may be a factor. It is considered, and the wishes are conveyed by a court-appointed guardian ad litem for the children. Historically, what the relationship has been between the parents and the children, their health issues, education, religious choices, the parents' ability to cooperate and get along with one another, the parents' ability to understand and recognize involving the other parents' involvement in the children. There are many statutory factors that the court would consider in the placement of the children. In the event that you and your spouse cannot agree as to either custody or placement and those issues are contested, typically what will happen under the statute is the court is going to order both of you to sit down with a court mediator to try to resolve those issues. If you're able to reach an agreement at mediation, then one of the attorneys, or if you're pro se, you would be required to draft a formal agreement, a stipulation and order that would be submitted to the court for approval, and that would be binding as to custody and placement. If you don't reach an agreement at mediation, then usually the next step in most counties is the appointment of what's called a guardian ad litem. That's an attorney that the judge appoints from a list that's maintained by the court of various attorneys in the county who are experienced in family court matters, children's matters, etc. And they become an advocate and represent the best interests of the children. And they ultimately make recommendations to the court about the placement of the children or custody if that is contested, after interviewing both spouses, perhaps meeting the children and talking to other collateral sources to get as much information as the guardian ad litem feels is necessary to make recommendations on the children's best interest. Some counties also have an internal department, family court counseling services with social workers that will also appoint a social worker to make an investigation as well as to the best interests of the children, what custody should be, what the placement of the children should be. That can get to be a long, involved process, and that actually can get to be a very long and expensive process as well. So it is always better, if you can, to try to reach an agreement as to custody and placement of the children on your own. Try to remember both parents have a right to be involved in the children's lives. all things being equal. And if you have to go the route of contested litigation over custody and placement of your children, you should involve yourself with a skilled family lawyer to assist you and help you to explain what your chances are, how long it's going to take, and what the expense of that may be to you.